audio is alright. Yes, you're good. Panel, the judicial system is the last line of defense to protect the most vulnerable, and this can only happen if you give judges the ability to do their jobs without being significantly constrained by administrative agencies. There are two kinds of setup there. The first is in terms of who these administrative agencies are. There are bureaucratic bodies such as the Environmental Protection Agency, which are in charge of implementing laws passed by the legislature. But secondly, let's talk about where statutory interpretation takes place. The first is where statutory language is extremely vague because of the use of terminology such as reasonable or appropriate. And for an example, the vast majority of that environmental regulations and statutes prohibit actions that lead to substantial impact, but it is extremely unclear as to what substantial impact amounts to in the first place. The second instance then is when technical terminology is significantly unclear. The opposition defends a world where courts are bound by the interpretation of these agencies. Our world is one where courts independently interpret the statute to determine the most reasonable meaning. We can also apply things in the skip-mode standard where you consult agencies and administrations on our side of the house to get technical advice. And judges can also bring in expert testimonies and independent technical advices in instances where they are extremely unsure how to rule. In essence, judges can use administrative agencies and technical advices as tools in a toolbox to make the best possible interpretations possible on our side of the house. There are two constructive arguments coming out of side proposition. The first is in terms of why judges make better interpretations, but secondly in terms of why administrative interpretations will lead to harmful outcomes on their comparative. The first argument then, in terms of why judges make better interpretations, this argument has three parts. The first is in terms of why judges are able to navigate technical interpretations. The mechanisms for this is twofold. The first is that courts are specialized into many fields such as labor law and environmental law, and the people who work in these courts as lawyers go on to becoming judges, which means judges have years and years of experience within these specialized fields while also being able to refer to past court cases and their precedents. The second mechanism then is that courts can bring in expert testimonies that act as an independent translation tool to make sense of the science behind things like drug regulation, for instance. Because panel, it is quite intuitive that it doesn't take a scientist to understand that data from a clinical trial that proves that a certain drug is addictive, is harmful and should not be put out into the market. Judges can make these value judgments on their own on our side of the house. The second part of this argument then is in terms of explaining why even if judges don't have the same level of technical expertise as technocrats, why they're still able to navigate certain interpretation processes and understand the overall implications of their interpretations. The mechanism for this is quite simple because the impacts of different interpretations are simple to understand because you can see them manifest in the real world from the ground up. This can be easily illustrated by the case of Massachusetts versus EPA in 2007, where there was a question of whether CO2 should be listed under the harmful chemicals list under the Clean Air Act. In this case, the EPA rejected the interpretation that CO2 fell under the Act because they were lobbied by oil companies such as Shell and Chevron. In the court proceedings, which included extreme levels of peer review studies, proved that the success of regulating there was a significant level of success of regulating CO2 and its importance. In the end, the court ruled that the EPA was able to interpret that CO2 did fall under this Act. This proves to you why agencies are extremely self-interested and why judges make good decisions. Now, opposition might think that this proves that reasonability is enough to prevent harmful interpretations from taking place, but they cannot claim this benefit because this case was taken to the Supreme Court, and this can only happen because deference is not relevant to the Supreme Court. Now, moving on to the third part of this argument, which is that the judiciary's job is to find the best possible meaning of certain statutes and laws, but agencies constrain them from doing this and restrict them to do what is permissible under the statute. Before I move into that third mechanism, I will take that one.
So how would a judge who doesn't really have any degrees in a specific field are able to just evaluate conflicting research of like epidemiology, for example?
I think I've already significantly explained to you why this is true just now a couple of minutes ago, which is that even on our worst possible case where you can possible interpretation from taking place. Opposition's world is one where the most permissible interpretation takes place. But panel, permissibility doesn't equate to harm reduction on that comparative. Like refer to the example of the EPA where the permissible interpretation was to include a bunch of harmful pollutants but to exclude CO2. See, this is harmful because CO2 will continue to be unregulated, harming millions of people on their side of the house, and pushing climate change to a point of no return on their side of the house. In that, on our side of the house, judges will not differ on our comparative, and they will understand that CO2 is bad and should be regulated. That is why we make the best possible interpretations on our comparative. The second argument then is in terms of why different to administrative agencies will always lead to bad outcomes on that comparative. Let's first talk about instances where judges will disagree with agencies. The most likely manifestation on opposition is where permissible interpretations take place. But I've already significantly established to you that the point is that even if the interpretation is permissible, it is still significantly harmful. For example, in the UK, the government can seize land for private companies under the guise that it is for public use. The New London Development Corporation redefined public use to mean economic development, and they transferred that land to Pfizer. This hit millions of working class families and hundreds of thousands of them to the curb on their comparative. In our world, judges simply will not be satisfied that this is permissible and will push for the best possible interpretation, which is likely to protect far more people on our comparative. The first part of this argument then is in terms of why agencies have incentives to give into corporations. Three mechanisms. The first is that different presidents appoint their own heads of agencies based on people who follow their agenda. This is exactly why the EPA changes its interpretation of what the law means with every change in administration. But secondly, technocrats heed to the beck and call of politicians because of the revolving door theory, because they want to keep the private sector in their good books to gain jobs in the corporate sector and push jobs at consultancies with higher levels of pay on their comparative, so that direct incentives to not pass regulations that cut to their profit margins. But thirdly, let's talk about that. But the second part of this argument then is in terms of why there's a lack of accountability to prevent this. So even if opposition says there's Separation of Power Act, I want to point out that this is not a good enough accountability mechanism on that comparative in the context of party politics, where one party controls both the presidency and the legislature. For example, in the US right now, the Republican Party controls all three bodies in the US, which means you have no accountability mechanisms on your comparative. The third part of this argument then is in terms of why deference prevents judges from doing their jobs, which is judging. On that, and I'm going to prove to you why that's far more better on our side of the house. The mechanism for this is simple, which is that judges have things like lifetime tenure, which means a direct incentive not to give in to the beck and call of the executive and to keep their jobs. But secondly, there are significant amount of penalties for giving into bribes and things like that, and therefore we're going to hold them accountable to a significant extent. For all these reasons, we urge you to side with side proposition.
Thank you for that speech. And can I please request first opposition speaker to open the case for opposition? Kirtan.
Can I be heard at this volume? In courtrooms across the world, scientific evidence is being ignored by judges who lack the capacity to understand it, and corporate money rewrites the rules that protect us. We end this auction of justice by letting those who know the science, not those who know the judge, interpret our laws. We're very proud to oppose. I want to talk about two arguments in my speech. Firstly, on why agencies set better standards. Secondly, on corporate capture. But first, I want to make a few responses and talk about our setup. First, I want to talk about their second argument on how agencies have bad incentives. I'm going to clash directly with their first argument on why judges have better incentives in my argument, so I'll talk about the second argument here. They say that they have bad incentives. They can do things like electing heads of agencies. But I have a few responses against this. Firstly, we say that agencies are held to the standards of administrative law. This means that they are required to file RIAs, which exist in many developed countries in the world, which must demonstrate things like empirical data to back your decisions. You have to consult with impacted stakeholders. You have to consider alternatives and justify rejecting them. These are the kind of accountability measures that exist for many agencies in the status quo. I really don't understand how their side will suddenly lead to lobbying for bad incentives by corporations. No, thank you. I'm gonna weigh this later in my speech as well. Let's move on to my setup. The model we defend, much like the precedent set in Chevron, is as follows. Firstly, we would only defer to interpretations in agencies' formal public documents, ensuring transparency. Secondly, we would only defer to agencies when statutes are ambiguous. Thirdly, the interpretation must be a reasonable reading of the law. So this means agencies are still limited in their powers to what the legislators intended. Fourthly, just like unambiguous statutes are up for judicial review, so is the interpretation of unambiguous laws. Meaning, if an interpretation makes a law violate the Constitution, human rights, international law, or administrative law, it can be struck down by Supreme Court. First argument then, on better outcomes. There are two layers to this argument. Firstly, on the quality of decision, and second, on preventing unpredictability. First layer then, on quality of decisions. Why do agencies have the unique capacity in terms of the expertise and tools required to shape interpretations? I have a few mechanisms here. Firstly, on specialized knowledge. Judges might get expert opinions, but they lack the specialized knowledge to understand what experts say and weigh into the decisions. Unlike what proposition says, no expert can explain complex economics or epidemiology to a person without even a first degree in econ or medicine. On the flip, agencies regularly employ the best experts in their field for decision-making positions. Like the Federal Reserve has the world's best economists, CDC has the world's leading medical scientists. Secondly, on dedicated time. This is where we think there's a huge difference. In the overworked and understaffed judiciary, time crushes nuance when judges handle different cases daily, then revisit each case months later after forgetting crucial details. This is what happens in courts. But in contrast, government agencies are solely responsible for implementing laws in their field, allowing them to dedicate thousands of hours by a large team to work towards the best policies using data analysis and talking with stakeholders, looking at comparable different policies in different countries. What are the impacts of this? Panel, having the best data-driven statutory interpretation is nothing short of a matter of life and death. In the lead-up to Rana Plaza's collapse in Bangladesh, factory inspectors identified cracks and ordered evacuation. But when factory owners challenged what constituted immediate danger in the court, judges who never studied structural engineering couldn't evaluate the technical evidence. 1,134 died the next day. Technical experts saw death. Legal experts saw ambiguity. When the Philippines tried regulating prescription drugs, courts had to interpret what constituted essential medicines. Judges ruled that branded drugs couldn't be substituted with generics for safety reasons, but health experts knew the generics were identical. So medicine prices stayed 300% higher than neighboring Thailand, pricing out millions of Filipinos. Judges couldn't evaluate the pharmaceutical evidence showing bioequivalence. When human lives are on the line, we're proud to stand on the side of expertise over ignorance. I want to talk about the second layer in my argument, on preventing unpredictability. The mechanism for this is on preemptive versus reactive setting of standards. Judges only interpret laws after disputes have occurred, which leaves stakeholders uncertain about their rights and duties. What's even worse, under a props world, even companies that fully follow agency rule can still be sued and fined liable. Agencies set standards in advance, on the other hand. This gives market actors certainty about the regulatory framework they have to work with. The impact of this layer is twofold. Firstly, principally, this is wrong because relevant parties are punished for breaking rules they couldn't foresee. But secondly, on a practical level, the uncertainty around the rules makes laws harder to enforce. This not only raises litigation costs in general, but becomes an additional barrier for small businesses that cannot afford these costs, creating a disproportionate chilling effect on their operations. Before I move on to my second argument, I'll take the field.
Trump's DOJ and DOD uses vague interpretations of outdated legislation to unjust deport people. Courts cannot rule against this because they have to defer to agencies. What have your administrative law standards done to stop this?
Yeah, I think I gave you a bunch of mechanisms on why there are accountable measures against agencies exist in the status quo and how they have to release probable measures and they have to talk to different stakeholders. I'm really unsure why that is only possible on our side of the house. But if you want to engage in this, I'm going to talk about why corporate capture and things like lobbying exist more on your side of the house in my second argument. Big corporations regularly abuse legal procedures to set precedents that benefit them at the expense of ordinary people. This looks like courts allowing pollution under vaguely defined safe levels in Lead Industries Association (LEPA), harming the health of local communities. This looks like courts letting insurers deny life-saving treatment by narrowly defining medical necessity in Rickline v. State of California. These bad rulings then become precedent for all future cases. Why is it easier for corporations to influence courts than agencies? 4 mechanisms here. Firstly, the process of persuasion. In courts, one judge meets lawyer, often in many cases in private chambers and decides alone, whereas in agencies, multiple experts must agree, transparent records, oversight, and public pressure exists. Secondly, on exhausting the opposition, corporations use the economic asymmetry between them and the plaintiffs to file endless appeals and challenges, knowing that the weaker party has less capacity to weather through the trials and will eventually drop their cases. In contrast, you can't just exhaust a politician or an agent, you must actually successfully persuade them. Thirdly, on judge shopping. Corporations often exploit the system through judge shopping to get favorable rulings. They file lawsuits and drop them when getting an unfavorable judge, only to file them again as many times as needed until being assigned a favorable one. In contrast, when lobbying politicians or bureaucrats, you can't just choose which people you need to convince. You must persuade whoever is in power and persuade a large group of people to get your way. Fourth, on forum shopping. In many regulatory fields that involve transnational litigation like IP, privacy, and tech, MNCs even get to choose the jurisdiction that they file a suit in, allowing them to be judged under the most favorable regimes. In contrast, when lobbying an agency, they must convince the agency their own jurisdiction, which significantly limits their ability to evade liability. Panel, even if you don't buy this claim and assume both courts and government agencies engaged in lobbying, we'd argue that lobbying courts is comparatively more harmful than lobbying agencies. This is because even the lobbying politicians and government agencies are directly subject to public support in the election. This is the most proximate and existential consideration for politicians and the agencies controlled by them. If the public doesn't support them and don't vote them into office, lobbying just doesn't matter. This isn't true for courts that are perceived and preferred to be independent. They are not democratically elected, and their terms are much more long-term because we don't want them to be swayed by the whims of politics. This illusion of impartiality uniquely allows room for particularly pernicious forms of corporate capture that disproportionately favor large and powerful actors, even at the expense of interests of people on the ground. Justice must not be an option we're very proud to oppose.
Thank you for that speech. Can I request second proposition to continue the case with proposition?
say judges are not experts in the field. That depends on what the field is. If it is legal interpretation, that has been emphatically the province and duty of the judicial branch for at least 2 centuries. We are very proud to propose in this motion because we think judges are fundamentally better actors. The first thing I'm going to do is talk about the mitigations that they want to pull out in terms of why agencies are better. I'm going to deal with that as my first question. Here's why we believe the agencies are just fundamentally bad actors and why their responses don't work. Firstly, in terms of their response, in terms of RIA, the problem is that these standards are very hard to apply because of their own mechanism in terms of why it's hard to take these agencies to court. But secondly, empirically, even in developed countries, it is just more likely that these agencies are able to get away with these sorts of things like we see in the United States, for example, where RFK Jr., the head of the CDC, is claiming actual medical misinformation in terms of, for example, the way autism is caused by things like vaccines and whatnot. And the reason why agencies are able to get away with these sort of things is because they operate on a top-down hierarchy where they hire and fire people based on whether or not they subscribe to these sorts of agencies, and they're able to gain support from the federal government. So even if a lawsuit is brought up against them, they're more likely to be able to win against them in the first place. And usually because the state prosecution is equating the federal government as a whole, the incentive to actually hold these agencies accountable falls because that isn't in their incentive to do so in the first place. But secondly, I also want to talk about the ability for you to apply this motion in developing countries, because this is especially true and all analysis becomes amplified in developing countries. This is because things like nepotism and corruption are more prevalent in these sorts of countries, while because of the separation of powers, courts tend to be more independent. But I'll get into that later. I'm going to talk about why politicization is extremely harmful, because primarily you assert arbitrary interpretations which just harm people in general. But secondly, corporate capture by doing things like, for example, lobbying these sorts of agencies is inherently already legal. Meanwhile, the revolving door incentive as well as the ability for these agencies to install people within these agencies probably means you're going to adhere to these agencies in the first place. And especially because developing countries tend to be more dependent on things like FDI. Any sort of counter mechanism in terms of backlash also doesn't happen simply because these are low visibility issues. The implication then is that even if these agencies have the expertise like they want to talk about, I fail to see why it is actually in their incentive to utilize it objectively and effectively and not in sort of biased and politicized manner. Here's where I'm going to flag our comparative by flagging our positive construction here. In terms of why we're able to reform these agencies on our side. This is the case because of our comparative, we are able to provide an active incentive for these agencies to reform. This is because of our comparative, we push the burden of proof into these agencies, where they themselves have to present a compelling and reasonable case for these courts to actually be willing to buy this interpretation. This is important because of legal principles like the best possible reading. All this means now is that agencies just become more technocratic on our comparative because they have to adhere to these standards. On opposition, they become more complacent, lazy and politicized like we see in status quo. And we see this empirically when the Australian High Court ruled out Chevron deference very recently, and we've seen that Australian agencies just tend to be more technocratic and stable. But importantly, I want to flag another extension here. That is because of the inconsistency in terms of agendas and administrations. You have environmental agencies or other agencies constantly changing their interpretations of the law. Here is the impact of this, and here's why it's so harmful. This is because ambiguity enables different sorts of interpretations all the time, meaning very important implications in terms of legal implications are brought down onto vulnerable people. For example, when in terms of ambiguous laws, in terms of immigration law, these people are in legal limbo because they do not know all their rights and they're constantly being relocated or deported without knowing what due process is in the first place, because that very due process is ambiguous. They do not know their rights and how to defend themselves. We think that is extremely harmful on their comparative. I'm now going to deal with the question in terms of judges, but before I do that, are there any POIs?
Yeah, at least bad decisions by government agents can be corrected because voters can hold them accountable. A new government can step in and amend the law. The voters are powerless to amend a bad precedent in court.
Okay, here's what I'm talking about reversibility, because that is a very convenient segue. The problem is, think about how high burden your metrics of reversibility are. You either have to A, go to the Supreme Court, requires a lot of time, capital and political capital because you need a class action case, or secondly, you have to vote in a whole new government. Think about the collective action that requires, the buy-in that requires. The problem is administrative agencies are just low visibility. Nobody votes in the government because of who's heading the Environmental Protection Service or the CDC, for example. People vote for the president because those are more high voter issues anyway. But also just stuff like populism, the incentive for you to care about technocrats when it comes to democratic processes is just inherently low. But compare this to our comparative when it comes to reversibility. That is appeals. Appeals on our comparative become far easier. This is the case because now when you launch an appeal against a court that makes bad interpretation, you are only fighting against a singular court compared to the interpretation of an entire executive and administrative agency. This is very important because firstly you will have less of a deterrent in terms of actually taking these things to court, but importantly you do not have the negative feedback loop that opposition experiences. Because think about it, you have a bad interpretation that then has to get taken to a higher court. This higher court ends up deferring to that same exact agency because of the fact that that is past precedent and because that is how things are traditionally done and because of all the perceived analysis that they themselves present. It means it is very hard for you to actually go against these agencies because the precedent on their comparative is that these agencies are the one who ought to be interpreting these. Now I'm going to get into my clash in terms of judges. Primarily that judges just aren't corrupt like they want you to believe. Like corporate capture and the things that they want to talk about on that comparative just aren't realistic. Like they use rhetoric about whether you know the judge or not, but that is just blatant bribery and a conflict of interest. And courts work very hard to actually minimize the extent to which this is happening. And think about it intuitively. Judges are going to have a lot to gain if they were to report things like attempted corruption by corporations because of their reputation and their pathways for success and all that. This just means that judges are more likely to report these things because it's good for their incentives as well, and corporations are just going to get screwed over in the process. So corporations preemptively don't want to implicate themselves in these sorts of proceedings anyway. But there are a bunch of external mechanisms as to why you're able to hold judges accountable. Primarily because of judge rotations in terms of specialized in terms of these courts. Because oftentimes these judges are randomized and aren't able to a very last second. But also when you're fighting against agencies, you're able to, for example, cases can't be dropped by the person who is being accused, or it's often up to the plaintiff. And if there is an actual extent of harm, the plaintiff is able to receive things like a pro bono case and all of these things. So you're able to actually go through with the court even if the corporation doesn't like where this judge is coming from. But also you have judicial councils, watchdogs, the separation of powers and social scrutiny, financial disclosures and fixed tenures, which just reduce the incentive for these judges to actually take things like bribes in the first place. But furthermore, we are now going to prove why judges just have the inherent capacity to deal with these sorts of cases in the first place. Firstly, I want to argue that a lot of these instances of ambiguity isn't about hyper-technical specifics. In gun law, stuff like common use doesn't require extensive knowledge about guns, but rather how these things work. We think that they have, for example, lawyers who are competent and able to actually present the argumentation, the implication of this analysis, and we think that is effective. Secondly, you're able to gain things like expert testimonials and you're able to simplify concepts. In debate, we are talking about these very technical legal concepts, but you as an average intellectual voter are able to understand these things. So we think it is possible for you to actually do these things. And judges are just inherently smart people. They're given the responsibility of whether corporations have to pay millions of fines or send someone to death by a death penalty. Because that's a very high standard of the types of people who are brought and turned into judges. We think that these people are just especially have a greater capacity. And importantly, even if you don't understand these concepts of law, you're able to understand the implication. If you subscribe to one definition over another, it just means that you're able to understand what sort of impact that has. And because judges care about broader metrics and not just, for example, the legal permissibility of an interpretation, we think judges are automatically become more holistic on our side of the house. We think that because of these sorts of things, you're able to deal with these sorts of things. We think that for all these reasons, you should side inside proposition.
Thank you for that speech. Can I request the second opposition speaker to continue the case? Very good.
Statutes do not speak for themselves, and when their words fall short, someone must breathe meaning into them. The question is who? Prob would have you believe that judges, distant from facts and detached from the field, should override the very experts who live and breathe the law's application every day. But interpretation without expertise is not justice, it's it's guesswork. Two clashes, first on outcome, second on manipulation, finally an extended third argument. First, on outcomes. The main challenge we get against our idea is agencies have incentive to use their capacity in bad ways. Why then would we argue agencies have incentive to use their capacity in good ways? One, agencies to some extent are held to the standards of administrative law. This means they're required to file things like regulatory impact assessments or RIIs, which must demonstrate empirical data to back their decisions, have consulted with impacted stakeholders, and having considered alternatives and justified rejecting them. It also means government agents are criminally liable for breach of their statutory obligation, which require them to be impartial and detach themselves from decisions they are partial about, refuse to accept any form of bribe, avoid use inside information because of any past occupations or future occupations, and be held to a freeze period after their exit from office when they cannot work in related industries. Second, agencies are accountable to the government and by proxy to the voters. If an agency does a bad job resulting in bad outcomes, this will create public backlash that politicians will punish the ones who are responsible for it. They say agencies have low visibility. The problem is there is massive incentive for opposition parties to capitalize on agencies being bad and actively call us out, which crucially creates more visibility when agencies are being bad, even if this is not regularly a thing. Thirdly, people who work in government agencies just tend to genuinely care about doing the best job possible. These are experts who chose a public sector job over a private sector job because they care. These are people who have decades of these are people with decades of experience behind them who learned to look up and admire the best in their field and want to become like them. But finally, if their interpretations are made in a way that's unfair or unjust, lacking due process and cannot be justified, in these cases alone, obviously, courts can also intervene in our world. I would further argue that even if you, and all of this talk about government abuse of power is dealt with there. Yeah, go ahead.
In debates, the judge is an informed and average voter. They don't have to be specialized in econ or law to judge around because they are smart enough to navigate it. As we as debaters are expected to convey our concepts and impacts clearly. Is that not similar?
I don't know if you've ever done an economics debate before, but I would say you like no debater, unless they're studying economics, is that good at making the correct economic arguments and can evaluate this very well. Our first argument proves all of the specialized knowledge that is necessary, but furthermore, even if specialized knowledge to some extent is able to be done by these lawyers and by these judges, we talked about the lack of time and the time crunch that causes such harms to manifest. Let's talk about their three mechanisms to attempt to prove judges' capacity to navigate technical fields then as a segue. Their first idea is courts are specialized. The problem is, oftentimes courts aren't specialized in specific areas, like there's no environment court that you can yield to for environmental lawmaking. But also secondly, this is just oftentimes less true the higher up in the court ladder you go. There's no environmental Supreme Court and there's no housing Supreme Court that we can yield to when we're making statutory interpretation. Their second response about rigging and experts, our argument already preemptively deals with. Their final idea is about the impacts of the interpretation can easily be visualized. Like, I don't understand if you've seen law before, but it's really hard to visualize some of these things. Like, even if we were to, for example, debate on what the standard for what a vehicle that should be regulated under environmental law is, it's unclear to what extent this harms the environment, and it's very hard to visualize this. But also, secondly, judges to that extent can only visualize the specific case in front of them, and cannot therefore visualize the precedent that they set or the future extent of harm that may manifest as a result of this, so interpretation being visualizable is just wrong. There are two sub-ideas that come in their deputy that somewhat connote to better outcomes that I want to deal with before I move on. The first idea is about predictability. The main response here is to note the crucial difference between predictability and stagnation. The law is evolving, and this is a good thing. You're happy to stand behind laws changing in accordance with changing values, circumstances, new information. What it is not is unpredictable. When agencies change their protocols, they make this public. Everyone knows of the change, and it only applies prospectively, not retrospectively. Further, they usually give a notice before they give the change to give markets time to apply and adjust gradually. Obviously, they have incentive to do this. In contrast, when statutory interpretation is decided in courts, this actually creates actual unpredictability. There's no prior guideline. The standard is left unknown until it's decided in court after a dispute has already occurred. And once a verdict is given, it applies instantly with no transition or adjustment period. The other idea that may implicate two better decisions that they argue is about how holistic understanding can only be done by judges. Firstly, I would flip this. Judges are biased towards the case they're looking at. Agencies are interpreting statutes without a specific case in mind, which allows for more holistic understanding. Second, this holistic understanding is sometimes just bad and compromises the specific context of the law at hand. Judges use broad legal concepts and precedents from unrelated field. They apply the same definition of necessary to environmental law that they use for tax law, but these words mean different things in different contexts. Finally, agencies also understand and consider different viewpoints. They have advisors from various fields, work in collaboration with other agencies, and hear claims from various stakeholders. They in fact have much more time to collect all of these different perspectives than courts do, which engages further thinking about holistic understanding. Second question, on manipulation by big actors. Firstly, I want to be with the assertive claim from their bench that this is not factual reality. In International Shoe Corporation versus Washington, the USSC expanded the concept of personal jurisdiction to allow court to hear disputes over defendants who had only minimum contracts with its jurisdiction. In Philip Morris v. Uruguay, PMI instructed its ownership so that the Uruguay subsidiary became held by a Swiss entity, enabling access to arbitration under the Swiss courts to circumnavigate courts and challenge Uruguay's tobacco packaging and anti-smoking regulations. Forum shopping is a very real problem. The other and better response you get is this idea of regulation. But if Prop wants to regulate against it, I would like to see him succeed where many governments have failed. Corporations can easily, for example, change their headquarters or subsidiary regulation, etc., etc., etc. Finally, in the last 1 minute and a half of my speech, an extending third argument. Third argument. Agencies have an interpretation that is closer to what the legislator intended. Legislators' intent is what we should principally strive for when interpreting the law. First layer, why agencies' interpretation is closer to the legislator's intent. 3 mechanisms. 1, the government appoints agents with a deliberate intent to execute its broader ideology. In contrast, judges and courts are nominated by an independent committee, making their understanding of the law divorced from what the legislator intended. Second, agencies work alongside the government through the legislative process and regularly meet and consult with government departments. In contrast, judges grow from the academy and private sector into courts, never passing through parliament. They lack familiarity with lawmakers and with the process of lawmaking, making them ignorant to the considerations behind choosing specific terms. Third, agencies are accountable to the government. They rely on it for budget authorities, promotions, and demotions. In contrast, judges have little interest in legislators' intent as they're nominated for life, and their careers are immune to government decisions. A very good feature of judicial overview, but one that is bad for statutory interpretation. Second, and more importantly then, why does this mean that we must principally reject this motion? Panel, the conclusion of the analysis is simple. Agencies' interpretations are what the legislator actually intended, and judges are therefore bound to them just like they are to the law. This is winning independent of the practical clash because the justice system isn't designed to make the best laws. That is not its mandate. The public voted in the people whose mandate it is, and these people delegated this power to those who best represent them. Statutory interpretation are no different. They meaningfully change laws and reflect value judgments, and when such value judgments are made by the government by proxy of its agents, judges have no rights to intervene by the same exact reasons that they have no rights to intervene in an unambiguous statute as Prop himself conceived. For these reasons, Purple opposes.
I thank that speaker for their speech and request the third opposition speaker to conclude with the substantive case. Here we go.
At the top of my speech, I want to point out that the third argument is absolutely ludicrous. The point of having a separate judiciary is to check the legislature. If the legislature passes legislation that is harmful towards individuals, if they are susceptible to corporate capture, the separation of powers exists so that the judiciary can check the legislature. Them conceding to the dissolution of the separation of powers is just harmful. Like, I will prove in the corporate capture case, when I am impacting that out, why not having a separate body to check the legislature and possible harmful interpretations of the legislature can lead to direct impacts that harm individuals on the ground. 2 clashes in this speech. Firstly, before that, I also want to point out, and this is something I want to clarify, that their claim that agencies make interpretations, like just in general, isn't really relevant to this debate. Because this debate is about when statutory interpretations are deferred to agencies by courts. So court cases have to come up in the first place for courts to defer to administrative agencies to make statutory interpretations. The implication of this is that 1, this takes out their first speaker's argument on unpredictability, because it is equally unpredictable when you still have to wait for court cases to come about, and 2, it takes out the push that they make in their second speech that you are able to like gain benefits from having corporate from like being able to that you are able to gain benefits from having more predictability on their side. Firstly, in terms of corporate capture, I want to point out their claim is that administrative law and specific standards exist to prevent like harmful interpretations. The first thing I want to point out is that it is unclear what stops these pernicious interpretations from taking place. Sure, these standards may exist, but to what extent do these standards actually regulate what administrative agencies can actually interpret? We pointed out to you previously that there have been numerous instances where, for example, you have had city development corporations that use vague interpretations of what public use is to perniciously use eminent domain clauses to give land to private corporations like Pfizer. Even though that these standards exist, the fact that the heads of administrative agencies are appointed by the executive, that means that the administrative cronies that exist at the heads of these agencies are backed by the federal government, which means that even in the instance where you are able to take these people to court, there isn't much you can do about it. The next thing that I want to do is I want to respond to the plethora of mechanisms that comes out in their first speech and is extended on in their second as to how you are able to lobby courts on our comparative. The first broad response I want to make here is that their mechanisms are incredibly resource heavy. Like profiling judges, having to like go through years of constant litigation for that exhausting mechanism. I'll take you later. Years of filing and dropping cases. This is incredibly resource heavy. On the comparative, the revolving door on our comparative means that, or rather on their comparative, means that lobbying administrative agencies is just a lot easier. These governments are openly lobbying. The heads of the executive will appoint individuals that they want in the administrative agencies, and therefore the statutory interpretations that take place will now favor the lobbies that directly lobby and openly lobby governments. So it is a lot easier for you to lobby administrative agencies than it is for you to lobby courts. But secondly, they have little to no accountability on their comparative. They want to use public backlash as a mechanism of accountability. We responded out to previously as to why public backlash is just not like to manifest. The first thing that I want to also point out, in addition to what we told in the previous speech, is that a lot of the times, instances of harmful statutory interpretations don't have sufficient visibility for you to be able to actually call people out on their comparative. For example, you may have a handful of homeowners that end up being displaced, maybe 100 immigrants that end up being deported due to harmful interpretations, but that doesn't get sufficient visibility for you to get the level of public backlash that they require. But secondly, people aren't aware of the incredibly hyper-specific terms and jargon under which these forms of negative and harmful statutory interpretations take place. No, thank you. And like people don't know what non-attachment zones are, what specific standards and ambiguities actually look like. So you are not able to make positive interpretations on their comparative. The next thing that I want to also point out is that when federal governments are called out, they often defer accountability to the agency. So they call out the agency and they replace the head of the agency, but it is still another government crony that ends up being the head of that agency. So it isn't true that on their comparative, you are directly able to gain benefits, or rather directly able to hold them accountable through public backlash. The next thing that I want to also point out, or rather respond to, is like, or rather bring up, is on as to why our mechanisms of accountability are more likely to work. One is that there is a massive level of scrutiny that that judges are placed under on our comparative. You have to literally disclose your financial assets when you take up these cases. Appeals courts exist. It is very difficult, and I would also point out that judges just are unlikely to want to accept these forms of lobbying to begin with, because they have a lot to lose. They have lifetime tenure. They have no reason to actively engage in taking up these forms of corporate forms of lobbying to begin with. I want to point out, and this weighing is important, even if it is true that there is a reasonable lack of technical expertise on our comparative, we have methods of mitigating against that on our comparative because of having expert testimonials on our side, because of the fact that you are able to have technocratic advisors, because judges are able to do things like view clinical trial testing and understand data and understand the impacts of certain interpretations, even if they don't understand the direct processes of them. What this all means is that on their or rather on our comparative, judges are better on our comparative. We have the the capacity to mitigate against expertise. But on their comparative, they have no ability to mitigate against corporate capture because their mechanisms of accountability just don't work. Before I move on to the second clash, I'll take that point.
Panel, don't let propositions American-centered bias fool you. Most countries have reasonable electoral systems that prevent this form of abuse. For example, most countries require government agents to undergo a freeze period for a few years after finishing their term in their respective agency, where they aren't allowed to work for corporations related to their administrative role. How would corruption still happen?
Even if you have to wait for a few years, governments can still appoint people that follow them and like ideologically support them. It is unclear to me as to how you are unable to still appoint government cronies on that comparative. So the second clash is in terms of expectation. They say that these things are very difficult for you to visualize. I want to point out that this isn't true. Graphical representations of the implications of using certain chemicals in water bodies, for instance, can make you understand how these things work. So even though these things may be difficult to understand, technocrats and people who have very high levels of knowledge within these fields and within these subjects have the capacity to directly show you what these actually look like on their comparative. They don't have the capacity to do that, or rather they have the capacity to do that on our side. The next thing that they say is that expert specialization means that you are never going to have the same level of expertise, or rather that specialized codes don't exist on our comparative. I want to point out that this isn't true. Housing codes exist, criminal codes exist. There are different types of codes that actively do exist, which means that on their comparative, or rather on our comparative, there is a level and degree of specialization that actively exists on our side. I want to prove at the end of this, we may concede that judges may never be as experienced and well knowledge as technocrats. However, they are still likely to have the experience and knowledge required to make legal interpretations by understanding the impacts and implications of certain interpretations. For all these reasons, proposed.
I'd like to thank that speaker for their speech and request that opposition to open the substantive opposition case in case of those. You just pick up the mascot.
Yeah. Thank you. Can I be heard? That's yeah, I'll start in the next 10 to 20 seconds. Three major themes in the speech. First, on the principle of this debate. Secondly, on the equality of the interpretations. Lastly, on corporate capture. Firstly, let's talk about the principle of this debate. Our claim was simple. The lacuna, i.e. the vagueness that is currently made within the interpretative process, is not a bug. It is a feature, and we must protect this on our side of the house. Let's take a look at the feeble response we heard from their side. The only one-liner that we heard from Dr. was to say, well, the purpose of the judiciary is to check the government out. Note, opposition's response is only valid in instances where governments act lawfully, unlawfully. But if you take a look at our model and the reasonable interpretation of this debate, when government and an agency just goes out of its mandate and just literally interpreted the law unlawfully, I think this is at the point in which even under our side of the house, courts can intervene. This is framing that we gave you first, that they even framed it for themselves. What this means is, I think this balance of separation of power wasn't our principle. In fact, our principle was about how we should ensure separation of power on our side of the house, which is a reason why they simply cannot win on this one equal response. And they need to concede
that there is a sufficient number of cases where judges make their own decisions on their side of the house, because it was in these instances where we say that this is principally illegitimate. Why is it that the principle matters most in this debate? On intuition, if courts have no mandate, it doesn't really matter if they would practically yield better outcomes. And the reason for that is simple. It is unjustified for courts to override democracy. If it were different, we would let courts legislate directly. Given that proposition cannot stand by this, we think that principally this is most important on intuition. But on weight mechanisms, two things. One, uncertainty. Realistically, sometimes courts have better interpretations. Sometimes agencies would. But the principle always holds. Secondly, in terms of subjectivity, because disputes that reach the courts are debatable and are two-sided, this means on practical outcomes, there's no clear right or wrong. Hence, it is pointless to point out that this outcome is good or bad. In fact, we just fulfill the principle which is more important in this debate. Now then, let's chat about the second class and the practical outcomes and the quality of the interpretation. On our scene, I want to chat about two things. First thing I want to talk about is the incentive of those two actors. The first thing I want to point out is that all of our second speaker work is just unresponded to. We told you numerous reasons why agencies are still held accountable by the administrative law, that they're criminally liable when it goes against them, and the fact that they're just held accountable by voters. And they say, oh, but the voters just don't care about it insofar as it is not visible. Here I want to bring back the impacts we brought to you from our very first speaker that we ignored. That in this one single case of Rana Plaza, literally 1,000 people were killed as a result of this one single interpretation. And if you look at their logic on how judges have the holistic understanding, etc., all of which is contingent on the cases where this has a large impact in the public, which is the reason why in important cases where there's an important delta on the two sides of the debate, I think it is fair to say that the public has an incentive to hold you accountable. The second thing they say is that what government will abuse power. Firstly, look at our model. When government agencies act in properly corrupt ways, chances are that they violate one of the many legal restrictions they face in terms of the constitutional law, in which case I think the courts on both sides of the house can hold you accountable. Secondly, and more importantly, I would note that this is not normatively back to begin with, right? Because tax agencies are nominated and supervised by the elected government. And if the government agenda is to maximize the tax collection and just redistribute it into welfare, for example, that is a reason why I think government is not abusing. It is catering to the public. Third of all, I think checks and balances against corruptions are built into a system because the majority of the legislators and of experts within the agency will need to collaborate to enable an agency to prevent the process of abuse to begin with. Opposition parties are not going to be benefiting from the abuse they say exists, which is the reason why corruption is non-minuscule in this debate. Finally, they say that agencies will uniquely have the incentive to improve on our side. One, I want to flag from the beginning, this is not really important because our incentive analysis and how we still don't have negative analysis and negative impacting and negative interest does not stand. So therefore, even if there's a marginal increase in the palatability of their incentive, it doesn't really matter. Secondly, there's symmetric incentive to improve on both sides of the house. The fact that you want to cater to voters, the fact that there's internal competition to just climb up the hierarchy within the agencies is the reason why we likely interpret and improve on our side of the house as well. Therefore, I think this just deals with our claim and how there's things like permissible or harmful interpretations that exist in our world, insofar as there's incentive to improve on both sides of the house. Second theme within this theme on incapacity. I want to talk about two themes under this. Firstly, I want to chat about why expertise is important. Because the proposition says that you don't need expertise to begin with. Why do you need expertise? Because when discussing what the exact minimum wage is, the problem is, it's not about the vague logic, right? It's about the econometrics. When you talk about the sufficient safety measures, it's not about some random logic. It's about the expertise that exists within it, which is the reason why I think it is from the lens of the judges who don't know anything about this field. When you just, even if you consult multiple different people, if they give you multiple different advices, you just don't know what to do. Now then, let's take a look at their positive material. The first thing they say is that judges have a better understanding of the law. Three things. One, understanding of the law is just irrelevant in this context to begin with. What does a law degree teach you about what the source means in this specific context? Two, government agencies employ legal advisors as well, which means that I think the law expertise is inexclusive. Three, again, from our side of the house, agencies are limited within the boundaries of reasonable interpretation, framing out the worst forms of harm. Finally, they say that the judges have a more holistic understanding. One, flip this argument. Judges are biased towards the case that they're looking at. Agencies are interpreting statutes with a specific case in in mind. 2, the holistic understanding is something that and compromises the specific context of the law at hand. For example, judges broadly use the concept and precedents from their related field. I don't think this is a good thing. I think we should apply the expertise that's uniquely available on our side of the house. The implication of this theme then is that in their world, you don't have the sufficient capacity. Thereby, it just takes down the premise of their framing and how you are able to defer in instances if agencies are persuasive. Before I move on to corporate capture, I'll take it.
Let's talk about your example of the factory building on itself. If a bunch of architects and engineers come up to a judge and say, look, the factory is going to collapse on itself, why would judges allow comparative just buy that interpretation?
So the first thing I want to point out is that your argument and how, judges will still be able to just act better is just contingent on the fact that the harm's already materialized in the real world. But in fact, in most cases, you still need to preemptively make interpretations when a lot of the things are broad and vague. Now, let's talk about corporate captures quickly. I want to note at the top that vast majority of our claims is unresponded to because the two responses they give you about incentive of justice and disclosure mechanism largely doesn't really deal with the nuanced material we provided you from the first speaker. But it wasn't about things like you needing to sway one single judge. It was about judge shopping. It was about jurisdiction shopping. It was about corporations taking control of the system where you are likely to just pick and choose specific judges that literally align with the predisposed biases that you have. But even if you don't take that panel, I want to do a range here. Let's be clear on the scale of the corporate capture we proved in our first speaker. Courts only adjudicate an issue when someone brings a case. These cases disproportionately come from larger corporations that exist in their world. This is because to sue an agency, you need to know the process in the first place and have the ability and the capacity and things like money to begin with, all of which is the reason why on their world, I think the corporations and the large companies have to just, initiate the case to begin with, in which case they either win or lose on both sides of the house. I think they lose.
Thank you for that speech. You just need a quick second to close up. Do you need to pick these up? Could you just pick the papers?
Yeah.
And while he's at that, can I just request the opposition to ask people to conclude the debate for opposition?
Panel, we have three paths to victory in this debate. The mandate of agencies to interpret the law, the unique capacity to design better regulation, and the prevention of corporate capture. If you remember one thing from my speech, remember this. Each of these is enough for win us this debate. Prop must defeat all three. Here's why. If courts have no mandate, obviously it doesn't matter if practically they would yield better outcomes. It's still unjustified for courts to override democracy. Had it been different, we wouldn't have settled for interventive power. We would have let courts obviously legislate directly. Since Prop doesn't, they obviously can't stand behind this. However, obviously the reverse doesn't apply to us. If Prop proves a mandate, it only proves a justification for judges to interpret differently, not an obligation to do so. Lastly, even if Prop proves a mandate and better interpretation, if we prove they lose on corporate capture, they should still lose. This is because if they lose dispatch, they effectively forfeit control of interpretation from courts to corporations who would shape the precedents in their favor. Even if courts have the mandate and the better interpretation on their side, corrupt private actors surely don't, and on a comparative, even an imperfect government agency should still win. Again, the reverse doesn't apply to us. Even if Prop were able to prove regulatory capture is worse than hijacking of courts, this is necessary, but not a sufficient condition for them to win. That is because regulatory capture still exists on their side as well. This motion doesn't eliminate them, but only adds more ways for corporations to get their way, even when lobbying fails. Hence, winning each of these clashes alone should suffice for us to win the debate. Thankfully, to make it clear, we won all three. First clash, better outcomes. The very first thing is on the navigation of technical fields. I responded to all of the three mechanisms they gave you first, so the intuition pump is this. Even if I were to be an economics expert, it is impossible for me to, in layman's terms, explain economics to a judge who can reasonably understand and make well-reasoned decisions to it. The second thing under this clash is on time. There was just no response from their bench against this mechanism. Judges only get a few days in total to evaluate cases, and they have to handle many cases at once. Crucially, this means even if they have the best incentives, they just don't have the time to make best decisions and to hear out everything. Thirdly, on holistic understanding, because we flipped their line of mechanism, judges can only see the current case, but the agencies see the entire statute and all of the implications of that. There was no response even though this was raised. And second, the last ditch POI save attempt from their speaker is this. If experts are correct, we would obviously do what they want. The problem is, one, I would start by pointing out that if Prop wants judges to defer to agencies' expertise, yeah, that's defending our side. Second, note how lazy this response is, and it doesn't respond to a lot of our analysis. For example, if judges don't understand the science, they can't be persuaded by it. If judges lack the time to evaluate the analysis, they won't be persuaded by it. If judges only see one case and not the big picture, they obviously can't be persuaded by evidence that failed to manifest in this one specific situation either. Second clash on abuse then. First, on government abuse. The problem is we gave a lot of incentive and capacity analysis from second speaker. On the level of incentive, we gave you 4 mechanisms as to why agencies have the best incentives and are unlikely to abuse. And on the level of capacity, there was a bunch of mechanisms from my deputy and from WIP about how we can out-regulate governments in this situation. The second thing on corporate abuse then. The prop analysis is revolving door. Obviously, we gave you all of the analysis as to why this is oftentimes not possible due to, for example, freeze periods, but also just their analysis here is just like bad. Like their mechanism for lack of accountability here is, oh, you control the Senate, House, and presidency, which means you can't hold them accountable. But obviously, agencies like the FBI that work to hold politicians accountable have nothing to do with the Senate, House, or Parliament. And then their comparative analysis is they have tenure and they also judges face punishments, but like judges face punishments, but so do agencies in our world. I don't really understand the comparative analysis. Our competing claim under this clash was manipulation by big actors. Crucially, regulation is insufficient in responding to this because no regulation can sufficiently take away the right to access legal procedure, nor the right to, for example, withdraw from lawsuit. So nothing can stop corporations from withdrawing lawsuits with unfavorable judges, nor from suing again if they have better legal standing, allowing them to keep going until they get the best judge. All of our mechanisms for corporate manipulation are not able to be regulated. They're the inherent traits of the justice system that uniquely harm their bench. For these reasons, oppose.
Thank you for that speech. Can I request the proposition reply to conclude the case of Prop?
This debate has been very black and white. Let's be a little bit more realistic. This debate is whether or not administrative agencies have more or less unilateral say in terms of the interpretation of these sorts of statutes, or are comparative if judges take a more multilateral approach where they take these agencies and these expertise into consideration in making their own independent verdicts. Let's talk about the median here. Look, really bad and just outright illegal interpretations by, let's say, the EPA ruling, for example, I don't know, some ludicrous thing as illegal or legal, doesn't really matter. Ludicrous and downright harmful interpretations may not really be passed in that comparative. Let's be realistic. But also, importantly, good interpretations that have actual legitimacy and logic behind them will probably be taken into consideration actually and have a similarly interpretation on our comparative. So the factor imploding on itself, let's consider you're a judge and a bunch of engineers and technocrats tell you, look, it's going to collapse, you should consider this immediate danger. Judges have the intuition and the capacity to therefore make that informed decision and will probably make that same decision on our comparative anyway, independently, because they have that same feedback from them. And you're able to preempt these harms because that's what those technocrats are there to do in the first place. This debate is about the grey area. I think a good illustration is about indigenous communities. If a zoning agency creates a proof of ownership expectation for indigenous communities to show that they actually own the land and have lived there, this is a permissible interpretation. Because fine, most people have documentation like proving that they own that specific piece of land. And the zoning agency has the right to make that interpretation because it's literally their job to set requirements about what you can use land for and all that. So it is a permissible interpretation because that is what the judges care about on their comparative. On our comparative, judges care about the best possible reading. So they have a broader basket of metrics that they want to draw from. So on our comparative, you probably have a greater likelihood that you're able to side with indigenous communities because you no longer just solely defer to what the agency says. Because that zoning agency was lobbied by, like, let's say, a bunch of oil corporations. And this brings me to my idea of influence. We told you that sure, it might not be impossible for you to influence the courts and make the courts act in your way. But think about the high burden. Like you have to keep changing, for example, like the place in which your jurisdiction is held, you have to keep shuffling court cases like the most you believe. That is a lot of money and a lot of time. Compare this to administrative agencies. You fund the FDA's research into food, like food poisoning, for example, and Red 40, that directly skews the results from that research in your favor. Or for example, you, encourage and give a platform to potential FDA head candidates, which directly gives them an incentive to capitulate to you. This is all legal in status quo and doesn't require the same amount of capital for these corporations, so it's easy for you to do that. Think about developing countries where nepotism and corruption is just given to your family and friends, so you don't even care about things like corporate tax or these sorts of laws. The response that we get, and this moves on to the idea of accountability and like reversibility, is that you have administrative law. But the problem is that in most countries, the executive and the legislature are more or less politically homogeneous. Think about the United States, or the fact in countries like the UK, the Prime Minister is just the head of the majority party in the legislature. All this means that the incentive, for example, of federal prosecutors to actually prosecute these agencies is less because they're all on the same side. I don't see Pam Bondi starting a lawsuit against all of the Trump administrative heads who have been doing illegal things in status quo because they all have that same political incentive. And even if that isn't true, the scale of which you have to take it to those sorts of courts and those sorts of cases is so high. Compared to our comparative, where you just have a singular appeals court, because these are all independent rulings, so that way judges are able to just be held accountable directly without having to go to such a large scale. If a single district court makes an interpretation, you are able to appeal that interpretation to just the next court up, instead of making it a huge, for example, burden. Compare this to the other alternative of just voting in a whole new government, which isn't likely and not really realistic, and I don't think they're able to prove that sufficiently. But I also want to talk about why you're able to be more consistent on our comparative. It is not that these agencies keep changing laws in a singular direction. They keep fluctuating between different interpretations. So a liberal administration will consider immigrants of a certain type to be legal. The next administration calls them illegal and vice versa, and continues to do such. This puts these people in legal limbo, and you don't have consistent legislation which directly causes harm. It is not the steady progression that they want to talk about. We think for all these reasons, we are better for the law, we are better for the people proposed.
I'd like to thank all the